Ladies and gentlemen, Namaskar and very good morning to you all. On behalf of Dr.M.G.R Education and Research Institute and Dr. R. Silvi, Assistant Professor, Department of Information Technology, delighted to welcome you all to this virtual faculty development program on intellectual property rights and patents. We are thrilled to witness such enthusiastic participants gathered to deepen their understanding of this significant topic. It's my pleasure to invite Dr. Kritika, Associate Professor, Department of Information Technology, to deliver the welcome address.
Institute. It is a 5 days virtual FDP faculty development program on intellectual property rights and patent, taking place from May 20th, 2024 to May 24. We are thrilled to have such a distinguished audience with us, and your participation and enthusiasm are vital success for this program. Today, we have a privilege to welcome Dr. Kapil Arya as our estimate speaker. Dr. Arya is a senior scientist in the Innovation Protection Unit at Council of Scientific and Industrial Research, New Delhi. I welcome you, sir, for behalf of our management and our HOD, Dr. Kanya. We looking forward for insight, discussion, and valuable learning experience. Welcome you, sir.
An engaging faculty development program on intellectual property rights. You empathize on the importance of understanding intellectual property and patents in today's academic and professional landscape with the perfect foundations as we dive into today's sessions. We are all eager to learn more and apply this knowledge to our respective fields. Once again, thank you for your valuable time and for gracing us with your presence and words of wisdom. Before we proceed with the chief guest address, I'd like to invite Mrs. D. Deepa, Assistant Professor in the Department of IT, to give the chief guest introduction.
Good morning, one and all. It's my privilege to introduce our chief guest, Dr. Kapil Arya, Senior Scientist in Innovation Production Unit, Council of Scientific and Industrial Research, New Delhi. PhD and postdoctoral fellow in chemistry and PG diploma in intellectual property right management. He has more than 15 years experience in the field of chemistry, intellectual property right management. SAR has prepared a legal document of more than 400 patent applications received from various CSIR labs. More than 500 foreign patent application review and prepare final document of office examination reports of patent application in the field of chemical science and submitted to various foreign patent office. SAR has reviewed 300 Indian patent office examination reports and new patent applications in the field of chemical sciences, biochemistry and material chemistry. Prepare a response, drafting the patent application and hearing notice response and submitted to Indian Patent Office, Delhi. Filed 50 copyrights, 40 numbers of trademarks, 20 designs, 1 ZI filling. Thank you.
Thank you so much, Mrs. G. Deepa, for that wonderful introduction. As we embark on this journey of explorations and learning, we eagerly anticipate our chief guest, Dr. Kapil Arya, Principal Scientist, CSRI, IPU, New Delhi, and wisdom on the topic of IPR overview, essential of copyrights and trademarks. Your presence here today not only enrich our program but also inspire us to strive for excellence in our academic pursuits. Ladies and gentlemen, valuable speech. Sir?
Yeah, thank you, ma'am, for your generous introductions. And today I just share my knowledge about IPR, specifically. We talk about the trademark and copyright, etc. And just I'll share my slides to you. Uh, just a minute. Window this. And hopefully my screen is visible to all of you. Yeah, it is a visible, ma'am, and I'm audible also.
Yeah, it's visible and audible, sir.
Yeah. Thank you, ma'am. Thank you. So this is the today we just discuss about the IPR overview and essential of the trademarks and the copyright. So as we know, the what is the intellectual property? Intellectual property is the one type of property which is related to the creation of human intellects, or we can say the whatever the creation by the human minds come under category of the intellectual property, like innovations or a drawing, painting, or a business, etc. So these symbols, image, all these are the things which are related to the intellectual property. And the intellectual property rights are the rights which are given to the creators or innovator to protect their intellectual property. So or we can say the intellectual property is the intangible assets of the human intellects, and it can be classified the trademarks, copyright, patent, designs, and geographical indications. So in perspective of the Indian intellectual property, so there is a several intellectual property, and these are the governed by the several acts and the rules, like the Copyright Act in 1957, Patent Act 1970, Trademark Act 1999, GI Act 99, Design 2000, and Semiconductor 2000, and same the Protection of the Plant Variety and the Farmer Right Act 2001. So the all intellectual property having the some maximum protections, because these are not given to the creator for the lifelong and to encash them. So they have some maximum protection timeline limits, and we have to renew all these things in every year or or after 10 years, which are the situated which are already in our act and rules. So
Sir,
just like
excuse
that.
me, sir.
Yes. Yes.
Sir?
Yes.
Sir, your screen is not visible to us, sir.
It is just I'll again reshare, ma'am. No issue. Stop.
No, sir, it's not visible.
So it is a visible now.
Yeah, now it's visible, sir.
Okay.
Now it's visible, sir.
So the intellectual property having some validity, like the patent have the 20-year validity periods, and we have to renew every years, and it is governed by the Patent Act 1970, which are amended in 2005. Same the trademark have lifelong protections, and after 10 years we have to renew, and these are governed by the Trademark Act 1999. Same the design having the 15-year maximum protections, and after 10 year for we have to renew for the next 5 years. Same the copyright also have lifelong protection, but and in case of the death of author, the legal head having the maximum protection 16 year. And the copyright governed by the Copyright Act 1957, which is amended in 2012. Same the geographical indications have lifelong protections, and after 10 year we have to renew geographical indications. So now we emphasis on the trademarks and copyright right now, and the trademarks we can see as with the name of trademark, the marker which is used for the trading purpose. So in our general way, we can see that when we start any, when we launch any product into the market, so first thing come in our minds, what is the name of that product. So when we create the name of that product, so then the name of product should be very catchy and very appealing, so the customer can attract to each other to that products. So when we draw any name of that product, so it is a reflect to the brand or image of that product. So the when you can see in the picture, there is one Abibas and the Adidas. So both having the products on in the shoe category. And when we both things Abibas and Adidas come into the market, so the customer prefer the Adidas over the Abibas, because the Adidas having the good reputations and having the prestigious image compared to the Abibas. So the trademark is the branding, and these are the keys to the success in the business and in the global markets. So in branding is the process, branding, or we can say the branding is the image of that products. So all brands are the not a trademark, but all trademarks are the brands. So in the brandings, we can see it is the process by which the name of identity of the company or a enterprises or in an organization is communicated. For example, I can say the Apple, Maruti, these are the big brand, MACD. So these having the specific image in a mind of the customer. Same the brand also allowed to company to differentiate its product and service from the competitor by creating to a bond with the customers, like the MACD, Domino's Pizza. So these the Domino's and the MACD both having the in the food chain sector or a restaurant sectors, but they have the differentiate with the customer can differentiate between two brand, MACD and the Domino's. So the branding allow a company to differentiate its product and the service also. So through the branding, it is the way by which a company launch and sell good services, or a community and communicating the essence of new products or a lines like the French fry, etc. Or it's reflect the general or a prestigious image in order to the attract more consumer. You can see in the picture, this is the picture of the French fry. One picture is a general French fry and another picture is the MACD French fry. So the branding is the reason, that's why the people pay 10 times more for the logo, because when we put the logo of the MACD on the French fry, it's the cost is around 1,100 rupees, and there is no logo, the cost of the French fry is only 10 rupees. So the branding is the reasons, that's why the people pay 10 times more for. So this is the when the people pay 10 times more, it is all credit goes to the logo, or they create the image of that MACD. So there is a successful branding where you can see that it is the catch the consumer curiosity also. When it is a developing a brand is a part of strategic business plans. And when we create the brands in the targeted what customer care about, like the articulate the precise value and the quality that relevant and of a direct interest. For examples, when I can talk about the Apple and the MI. So am I having the good reputation or a precise value or a quality that is a relevant or a direct interest to that one? Same the emphasis the feature that both importance to the consumers and quite differentiate from the competitor, like the like when I give the example of the Apple and the MI. So both having the so the customer can or a competitor we can easily differentiate from the competitor through the branding. And we can sell the brand outside, but also think about the motivating our partner or your employee in the development of the brands also. So the best example of the branding is the Coca-Cola. The Coca-Cola is the case study, and we can see the Coca-Cola is the introduced 120 year back, but still is the most sipped soda drinks worldwide, and credit is goes to only for robusting marketing also. So the Coca-Cola targeted audience are basically on the age, because the Coca-Cola emphasis on the age, they emphasis on the income or a family size, even they emphasis on the geographical segmentations for their brandings. And say they also cover the gender. For the examples, first when the company target young people around 10 to 35 year, and they use the celebrate in their advertisement to attract them, and arrange a campaign in university, school and colleges in eve of the Valentine Day. So the more and more young people can attract. They also targeted the middle age and older adult who are diet conscious or a diabetic by offering the diet coke also. And they also introduce the income and family size also. They introduce the packagings and size of the bottles and at various level to increase the affordability, and targeted student, middle class, or even the low income family also. And they also targeted the gender, for like the Coca-Cola Light is preferred by the females, which Coke Zero or Thumbs Up are the men favoriting due to the strong taste. So the robust marketing or a global advertisement, branding, portfolio marketing, competing with price, personalized social media, sponsorships, so all these things, or a classical bottles, font, logo. So all these things, due to all these things, the Coca-Cola is a still most cheapest soda drink in worldwide right now, and because it introduced in 1892 as a medical beverage, but still now it is the most cheapest soda drink in worldwide due to their robust marketing. So the marketing is the key success for the generate the brands. So when we further go for the trademark, so the trademark is the brand name, or a way, or we can say a kind of the visiting card that promote the image of the company, its range of the goods and service, and or we can say it is the a sign which are distinguish goods and service from one enterprises to the another enterprises. So this is the trademark is the marketing tools or a source of revenue through licensing. We can generate a revenue from the licensing our trademark to other one, or it is the also a crucial component of the franchisee agreement. For example, the McD and the Domino's, these are the very big brand or a trademark, and they give the trademark like the McFlurry, Big Mac, French fry. This is the example of the trademark of the McDonald's. So they generate a crucial component for the franchisee agreement when they make a franchisee agreement. So these are the trademark having the play important role for creating the franchising agreement. Same the it is the useful for obtaining the bank or third party finance. For example, if your brand having the good reputation in among the customers, so any bank can give the loan to that person or that customer. For example, in Apple having the having show the good image in the customer consumers, so that the anybody or any banking can give the loan very easily to them. And or other sense, we can say it is the valuable business assets. So the trademarks is the also give the two critical functions in the marketplace. First, it provide the assurance that my goods are the certain quality and consistency, because the brand are having the establish a reputations for producing which they retain the worth over the time, so that the consumers think the reliable choice for the buying, seeking good value for their investment. So they provide the assurance. And second one, the assistant consumers in making decisions about the purchase of goods. The main purpose of the trademark is to show the difference about the quality of the goods and service. For example, the Apple and the mi red mi. So the consumers can easily identify that the Apple is a much better than mi or red mi, because the Apple give the quality of the goods and service in the better way compared to the red mi. So when we see the trademarks law in India perspective, the first the trademark law are come under existence in 1827, and after that the codification of law come under existence in 1940. So the British government passed the trademark law for uniform or a systematic registration of India in 1940, and they come under the codification of law. After that, the Trademark and Merchandise Act come under existence in 1958, and after that, in 1999, the Trademark Act come under existence in India, and through the Trademark Act 1999, the definition of trademark is expanded, service mark is introduced, multi-class filing is allowed, or a registration or renewal period increase up to 10 years. And after that, the amendment occurs in 2010. Through these amendments, the Madrid Protocol come into force. Through the Madrid Protocol, we can file a single applications in the multiple jurisdictions, because as we can see, the all intellectual property having that territorial in nature, means where you have filed or a granted, your right is only strict in that country or that territories. So same in trademarks, when you file your trademark application in India, so that you have right to but encash that trademark in particular in India. If you if you would like to file, if you think that your trademark or your IP rights are come under across the global, you have filed your application in globally. And so through this one, the Trademarks Act, you can file the single application in worldwide through the Madrid protocols, which are common into force in 2010. So and after that, the Trademark Amendment Act of 2010, the notice of opposition period changed to the 4 months. And then the trademark rule come under existence in 2002, and which are amended in 2013 and 2014. Through this amendment in 2013 and 2014, the increase in official fees there. So there is a difference between the registered trademark and the unregistered trademarks. In the case of registered trademark, you have the statutory remedy under the act, and but in the unregistered trademark, the common law action will be applied. And in case of registered trademark, the infringement and the passing of both is applicable, but in case of unregistered trademark, only passing of will be applicable. And in the registered trademark, the burden on the owners on third party, but in trademark unregistered trademark, the burden of proof on owners on the proprietor. There is a major difference between registered trademark or a unregistered trademarks. So in fundamental principle, when we can see in the trademarks, the India is the common law jurisdictions, and it is applicable. The use of trademark take precedence over the registrations. So registration is a prime facie evidence of the rights in the marks, and the registration in some case we can see the entitled the prevention of the use of mark, even the class other than those protected. For example, the when we file our trademark application, there is a several classes. There is a 1 to 45 classes. 1 to 35 classes is related to the goods, and 36 to 45 classes is related to the services. So where you file your trademark application, you have to when filing your trademark application, you have to show the particular classes, and your trademark is only applicable to that classes only. So the registration in some cases is a prevention the use of marks even in class other than those protected. For example, of well-known trademark, the well-known trademark can enjoy the protection in the all classes, but the non-well-known classes of the trademark is only enjoy the protection in particular classes where there is a registered. So, and in another sense, we can see the registration of the customs watch notice mandate a mark to be registered. For in the custom watch notice, in that case, the registration of our trademark is necessary. And if the any person infringe our trademark, so in that case, if the police also insist the registration of the mark for enforcing rights by way of searching operation and the seizure operations also. So sometimes the takedown notice available on the social networking website require also the registration details. So the registration is the very important things in case of the infringement, in case of the seizure operation, so in case of the search operation, or in case of the custom watch notice also. So registration is the mandatory for the because in case of the unregistered trademarks, all these things are not applicable, so, and the common law action will be applicable. So the as I told you that the trademark registration is also a territorial in nature. Means you have registered in your country, it doesn't mean that your trademark is protected worldwide or abroad. So when you file your application, when you would like to application in or a protection in abroad, you have to file your application in abroad also through the Madrid protocols. So there is a several route for the filing the international application of the trademarks. If a country is a member of the Madrid Union for the registration of trademark administered by WIPO, this is a best thing that you have file your trademark application or a single application in the multiple jurisdictions. And according to the Madrid Union, there is a 70 member country members. So the member can apply to other member countries with one application, one language, and one set of the fees, and renewal also a very single procedures. So when we see the trademarks is not a new thing. Trademarks is all we can see in the ancient time also. And the first trademark commander existed in 14th century. The loan barrow, this is a beverage which is registered in UK. And the BAS is also a concept of the legal protection which are merged in 1882. And we can see the trademark, the watermark imprinted on the paper. This is also a example of one trademark. The baker marks, the marker put on the bakery products, is also an example of trademarks. Same the example of MACD, Hutch, Streets, Coca-Cola, Crossings, Gillette, Mastercards, all MacBay, Champagne. These are also an example of the trademarks, and these trademarks is identity the goods and their origins, and it serve a guarantee of unchanged quality of the goods, and it's act as a marketing and advertisement devices also. So, in the fundamental principle of the trademarks, in pictures, you can see there is a, picture of the car, picture of the engine, and picture of the logo of McVey. So, when we see the picture of the car is show the aesthetic, the safe of the car show the aesthetic value. Aesthetic means the eye appealing, and which can be solely judged by the eyes. So it is a subject matter of design filing. And the engine of that MacBay is a subject matter of patent filing, because how what part are indulged in formation of engine and how it is the functionalized. So all these things are the related to the patent filing, but the logo and the marka is, and these are the subject matter of trademark or a copyright filing. So there is a different type of trademarks. There is a collective trademarks, associate trademarks, service marks, sound marks, well-known trademarks, and certification marks. So first I'll take the products marks. Through the products marks, we can distinguish the services, one services from the other one, like the Amul, Nestle, Mother Dairy. All these things, Amul, Nestle, Mother Dairy, are in the come under the dairy sectors. So these such type of the marka are distinguish the services from one enterprises to the another enterprises, are come under category of the product marka. Service marks to distinguish the service. Apple, Google, MACD are indulged in the restaurant sectors. Air India is in the aviation sectors. Apple is the innovation technology sectors. Google is a reference sectors. Apollo is a medical sectors. So these are the service marks, and through this marker we can distinguish the services. Collective marks is also a distinguish goods and service by member of associations, like the Tata Sons. Tata Sons is not a particular one Tata company. Tata Sons is just like a group of company. Same the VI. VI is the Vodafone and Idea. Both Vodafone and Idea are come together and make a VI. So this is the collection of two, or we can see the service by the member of an association. It means the collective marks, a marka used to distinguish the goods and service that are the provided or produced by the member of organizations, and it is owned by the organizations, and it is used by the its members. Next one is the certification marka. Certification marka is only for the certification purpose, like the wool marka, ISI, certified ISO 9001, good housekeeping promises. All these are the example of the certification marka. Safe marka means the safe of chocolate, safe of Coca-Cola bottle, safe of car are the example of the trademark filing in the safe category. Patents marks is also a marks consisting of the patterns which are capable to identify the goods and service which are originating from the particular undertakings. And even the scent and smell is also come, we can file the trademark application. The particular scent or smell are also the example of eva is the example of the scanting success, and it is a registered trademark in India. So and come in category of the scant and smell marks. Same the sound mark is also, we can file the trademark applications like the Intel logo, Nokia tunes, Doordarshan tune, Window tune, or Samsung Galaxy tones. All these are the category of the trademark filing in sound marks. And another one is the well-known trademarks like the Apple, Microsoft in relation to any goods or a services, means a markup which have become so substantial segment of the public which use such goods and goods or a recipes. So in the trademarks, any marker which are capable of the graphical presentation bearing the ability to distinguish the goods and service of one business from those of another. So it can be a word, it can be a name, or it can be a signature, it can be a device, it can be a color, it can be a texture, it can be a graphics, it can be a motion, it can be a sound, or it can be a CF also. In these examples, you can see the one chocolate in the one chocolate there is a several trademark application we can file. The color of chocolate, the texture of chocolate, the word how we wrote is also example of the trademark filing. Even the label and devices are also a subject matter of trademark filing. So the some things are not eligible for the trademark registration, like the use of which would be likely to deceive or cause confusions, and a marker which are comprising or containing the scandalous or obscene matters, or a marker comprising or containing any matter likely to the hurt the religious sentiment of any classes, and some like the Indian national flag, name of national leader, Satyamev Jayate, all are not a subject matter of trademark filing. So when we can see the comparable between the trademark and registered trademark, the advantage is the registered trademark is protected and registered trademark is not protected. And symbol R is in a circle is a example of registered trademark, and TM is an example of unregistered trademarks. And so when we can see how to choose the trademark, next thing is that, so we can see the product are already made in the factory, but when we make the brand of that products, so we have to choose the particular name of that one. So through but brands created by human minds, okay. So when we choose the marker for the business purpose, so it should be a very stronger marker, so it cannot be easily infringed by the someone. So it should be a more distinguished or a arbitrary or a fanciful in nature rather than generic or a descriptive or a suggestive. For example, the marker that are unique and fanciful like the Nike, Pepsi, Kodak, Xerox, these are the fanciful. The word and device that are arbitrary, like a blackberry is just like a fruit name, but this is not a selling the fruit. This is a this marker is used for selling the cell phone. So this is arbitrary in nature. Same the camel is a clothing brand, but it is camel is an animal, but this logo is used for the selling the clothing. Same the mango is also a fruit, but is a used for this logo is used for the selling the clothes. So this is the example of the words and device that are the arbitrary in natures. And we have to, when we choose the trademark, that should be easy to remember, like the Dunkin' Donuts, Coca-Cola, PayPal. But we should avoid the generic marker like the batteries or a Timex, Baby Dry, etc. So or even when we generic, we have to avoid the generic term like the chair to sell chairs. And in the descriptive terms, we have to avoid the sweet to sell the chocolate, or in the descriptive terms like the oragula or a pure wool for 100% synthetic materials, or the marka and term which are contrary to the public order or morality, or we have not used the flag, memorial bearings, official hallmarks, emblem without a legal authorizations. So in the trademarks selection, there is when we keep in the minds that it should be create the inherently distinguished marka, and think about the fanciful name like the codex, and arbitrary marks and logo like the Apple for computers. And we also introduce the suggestive marker like the Sunny for heaters, and the marker which are easy to memorize and pronounce, which is the positive connections, and have no legal restrictions or a reason for rejection, for like the Twitter and Twitter, because the Twitter and Twitter have the same pronunciation. So we have to avoid this all these things like the Gincona and Zircona, because Twitter is already registered trademarks, and when we put the Twitter, So Twitter and Twitter is both are the in same pronunciations. So we and confusingly similar to the existing one. So we have to avoid all these things. And suitable for export material with the corresponding domain name which is not already used. We can select that those trademark. So the trademark can be inherently distinguished or it can be acquired distinguishedness. And we can, when we talk about that distinguishedness, there is a spectrum ranging from the distinguished to totally undistinguished. Or arbitrary word we can use like the Apple for computer, and now many more things like the Ariel for cleaning solution, Subway for restaurant chains, Reliance Fresh for retailing shopping centers. All these are the example of arbitrary trademark. And the Nikon is also example of fanciful. Kodaki is also example of fanciful trademark selections. And same the suggestives, when we can see the suggestives. So the suggestive trademark is distinguished and they will relate to some kind of quality and characteristics of that products, but it will not the actually describe it. Like the Mustang is a well-known trademark for the car, and Coppertone is also a tannin solutions are a good examples, but it is often not clear cut whether a trademark is suggestive or not. Same the we should avoid the descriptive words, because sometimes descriptive word trademark is not easily protected, or easily we can protect as in the right way, because these trademark describe a characteristics, quality, features, and purpose of that good or service, like the Mochi for shoes, and the Best Buy retail store, or a Bank of America for bank, and Bravely and Beer for Brooklyn Brewery. So all these are the example of descriptive trademarks. So these trademarks are all valid and enforceable because they are company have acquired distinguishedness in those marka. However, they were not enforceable trademark at first. And we should avoid the surnames, because sometimes surname can also be considered descriptive. In addition, the any laudatory term like the best, super, primes, and sometimes we have avoid the generic terms for the selection of the trademark. So in these pictures, you can see when we see file the trademark application like the Colgate or a Domino's Pizza. So Colgate is the coin words and the Domino's Pizza is a arbitrary words, but they having the inherently distinguishing natures. Same the sunglass and pizza hut. So sunglass and pizza both are the descriptive marker, but when we put the sunglass with the hut and the pizza with the hut, so it is acquired example of the acquired distinctionness. So when we talk about the trademark classification, as I can say earlier, that the trademark is a, when we file our trademark application, we can enjoy the trademark protection in a particular class. So there is a 1 to 45 classes. So 1 to 34 classes is related to the goods and services, good classes, and 35 to 45 is denoted to the service classes. For example, if I have a one device, scientific devices, which are used for the educational or a cultural activities, etc., or a scientific or a technological services, so I can file the same trademark application in two classes, classes 9 and classes 42. Classes 9 is related to the devices which are the scientific or electrical devices, and class 42 is the related to the service for the scientific and the technological service. The person can apply the one trademark into several classes, but when we file our trademark application and it is registered in the particular classes only, if we file our application is class 9 for the only scientific and electric device, anybody can file the particular device in class 42 for the scientific and technological services if we are failed to file our same trademark in the class 42. So my means is that the trademark applications, when we file and it is when we register the trademarks, it is applicable on the particular class only. So the ordinary trademark application means the single class of goods and services, and the multi-class trademark application, you can file your trademark application in the multiple class or a goods and services. And in the convention or trademark applications, a convention trademark application refer to the application for registration of trademark claiming priority from the convention country. And some are the provision of the registration of the name of chemical elements and the international non-proprietary names and the Bharsa Scout Guides, Lord's Buddha, Guru Gobind Singh, Pansil, ISO. These are we cannot file the trademark application on that one. And the well-known trademark application, the Biocon for pharmaceuticals preparations, business administrations, retail outlet and research, Mother Dairy, Raymonds. These are the example of well-known trademark. Well-known trademark applications or a well-known trademark can enjoy the protection in all classes. So, and another thing is that the color is also play an important role for the trademark applications. For examples, the Starbucks and the FedEx. The first application filed the FedEx by the black and white, and after that they filed the trademark, a second trademark application in a particular color in blue and particular. So the registration or a design marker in a black and white without a color claims generally provide the broader protections. So the black and white can enjoy the protection in all colors and the flexibility in use. Without a color claims, the trademark's owner is free to use in any color or a no color at all to support the registrations. So when we prepare the trademarks, now the question is how we will file the trademark application. There is a requisiting information. First we need the applicant details. We use the user information and user affidavit in case of use claim. If we have to file the trademark application prior to the prior usage, or in that case we have to show the we have to provide the user affidavit. In trademark representations, in case of logo designs, description of the mark is required, and in what goods and services details we have to provide, and authorization of the agent is also needed, or even the signature is also needed. So there is a trademark filing process is also having some jurisdictions. There is a 5 jurisdictions we can file. The Mumbai trademark registration cover the Maharashtra, Madhya Pradesh and Goa. The Ahmedabad trademark registry cover the Gujarat, Rajasthan, Union Territories, and Chennai trademark registry cover the Andhra, Kerala, Tamil Nadu, Karnataka, Pondicherry, and the Lakshadweep, and Kolkata, Assam, Bihar, and Northeast states. And Delhi trademark registry cover the J&K, Punjab, Haryana, UP, Himachal, Delhi, and Chandigarh. This is the trademark forms, the form TMA, and we have to give the nature of applications, and applicant must choose either for following category. Is this the standard trademark, or is it the collective trademarks, or a certification marker, or a series marker, or we have to whether application file in case of startups, small entity, because there is a reduction of the fees for the startups and the small entity. And name of applicant we have to show trading and particular address and address of the services, their mobile number and their and the application to register a trademark and sell unless a trademark is proposed to be used contain a statement that in which periods which the person by whom it has been used in respect of the all goods and services, and we have to provide the cash memo, we have to provide the GST invoices, we have to find the ITR detail if we claim the prior claim, or we can see the prior to the date of application of the trademark application. The applicant shall file a affidavit testify the such claim used along with the supporting documents. So in the trademark filing process, the registrar find the marker to be acceptable, and the marker after the registrar find that your marker is a subject matter of the acceptable, then the marker is published in the journal, trademark journal. So and after publishing in the trademark journal, there is a opposition window for 4 months, and the marker is open for the opposition for the period of 4 months, or anybody can interested person can file that opposition for that. If there is no opposition received by that trademark registry, your marker would then proceed for the registration. So the best practice for the filing the trademark application, you have to follow up, you have to careful review of the advertisement clipping, and timely you have to review the trademark journals also. So this is the workflow. You need the form TMs, you need the technical summary including the logo, marka, certification marks, and the power of attorney in case of the joint application. If there is a no joint applications, there is no need of power of attorney. And the trademark class, in which class that you can file your trademark applications, and the justification for the registration of the proposed trademarks, and how can you use in marka in business sectors on that one. So when you file your trademark application, either you file the single or in a multiple class, and after filing, you issuance of the official receipts, and within 2 days the formality check will be happens, and after that examination will be occurs, and if there is a no objection, your trademark is acceptable, and if there is a objections, you have to file the examination report within 1 month from the receipt of date of examination reports. And based on the reply of the examination report, the registrar think that is acceptable or not. If there is a still discrepancies in your trademark application, he can give an opportunity to the hearing here again. And after hearing discussions, your application can be accepted or rejected by the registrar office. And after accepted the trademark filing, trademark applications, it is published in the trademark journals, and there is a mandatory notice of opposition period of 4 months. If there is a no oppositions by anyone, so your trademark application is registered, and after 10 years we have to renew for next 10 years. So the ground of examination is, there is two ground of examinations. One is absolute and second is the relative grounds. Absolute ground is depend upon the against the either your application is against the public morality, or having the religious connections, or the kind, quality, entities, etc. And the relative ground examination is depend upon the identical or a similar prior applications, or a prior in term of use, or a prior registrations, or a application details, etc. So the registration can be calculated from the date of applications, and it is valid for 10 years. For in maintenance purpose, we have to file 1 year prior to date on which the markup validity is expiring, and the surcharge is the application for renewal filed within the 6 months from the date of expiry of the registrations. Now the case is the trademark infringement. What is the infringement? Infringement is the trademark is said to be infringed when a registered trademark is used by the person, or who is neither the registered proprietor, or nor the licensee of the said trademark in relation to the goods and service for which is registered. And it is the violation of exclusive rights which is granted to the registered proprietor of the trademark in India, is governed by the Trademark Act. There is a one example which are the trademark infringements, because in this case you can see the example of Mercury and the McDonald's. These are the identical or a distinctively similar to goods or services in respect to which trademark is registered. Both are in the restaurant sector. Mercury is also registered trademark in the restaurant sector, and same the MACD is also registered trademark in the restaurant sector. So these are the identicals or similar to the goods and service. Same, it is likely to cause a confusion on the part of public, or have the association with the registered trademark, or other sense we can say it's take the unfair advantage, or detrimental the reputation of the registered trademark. So some example of the famous infringement case study, Burger King. So the in the Burger King is also a restaurant found in US, and same the and it is registered, it is not registered, it is a restaurant founded by the Hoods family. Same the in US the fast food chain of the Burger King, it is not related to that one. The restaurant founder claims that the original Burger King is mine, and the is not for the fast food chain. So the court case between this restaurant and the larger Burger King food chain is well-known case in US trademark law. So as a result, that case, the restaurant Burger Kings cannot use the name Burger King outside the particular territories, and the because the outside the particular territories, the fast food chain is more popular than the restaurant chains. Same the Apple, because the iPad, when, because as we can see, the Apple Inc is one of the world most recognizable and innovative technology, but its iconic logo featuring a beaten apples as the subject of the conflict sometimes. Over the years, the Apple have faced the numerous trademark challenges. In 2007, the Apple faced a significant trademark challenges from the Chinese company, which are the ProView technology over the iPad trademark rights in China. ProView claimed that it's owned the right of the iPad trademark in China, and it is leading to the protected legal disputes. And ultimately, the Apple agreed, and Apple paid the $60 million to settle the trademark dispute with ProView, securing the iPad trademark rights in China. Same the Adidas, the strip of distinguishedness, the one a shoe branding Europe company BVBA, having the Belgian company seeking a use of two parallel strips on shoes, and Adidas have registered a European Union figurative marks in 2014, consisting the three parallel strips on identical wheels. So the mark sought for the registration by Shoe Branding Europe, and the mark relied on the Adidas to oppose the application from Shoe Branding Europe, because both the two strips and three strips are similar to each others, and the Shoe Branding company, which are situated in the Europe, filed the suit against the Adidas, and in the general court determined that Adidas failed to prove the acquisition of distinguishedness character through use of three strips marks, and they ruled in the favor of Shoe Branding Europe company and declared the Adidas mark is invalid in Europe. Same the in trademarks, the infringement and passing offs, no person can have the right to represent his goods as good as of another person's, or we can see the sells a low grade product with the logo of branded company, Head and Shoulder and Anti Dandruff, both are looking very same, but they sell the low grade product with logo of branding company, or somehow the similar view, and it is the misrepresenting is goods and service as that of another to customer of the benefit of the sales. So under the passing of action establish a goodwill or a major ingredients, or a unregistered trademark thus have a higher burden than the registered trademarks, and while under a infringement suit a legal right is already available with the plenty of. So in case of the passing of, the misrepresentation to the customer with the regard to the ownership of the products and service, and causing confusion among the consumer, resulting in the discussion or a likelihood to the damage and loss of reputations. So this is also one example of Honda Motors Co Limited and Mr. Charanjit Singh in Delhi High Court in 2002. The Mr. Charanjit Singh sell the pressure cooker with the name of Honda, and you can see you can already know the Honda is a well-known company in the field of the motor car, having the presence in all over world, and they use the trademark Honda by responded because when the use the trademark Honda by the Mr. Charanjit Singh dispute or create a confusion in the mind of the peoples, and the court have restricted the defendant from the using the trademark Honda in respect of the selling the pressure cooker with the name of Honda. This is the example of the trademarking. So when we classified between the trademark infringement and the passing offs, so the trademark infringement means the unauthorized use of the registered trademarks, and the passing off is the misrepresentation of the goods and service to deceive the similarities. And in form of protection, the trademark protect the document protected and the services, and in passing off the protected unregistered products. And in the burden of proof is on user in case of trademark infringement, but in case of unregistered trademark, the user is obligated to not only prove the similarity but also violation the business goodwill also. So there is another example of infringement case, the Superstop and the Vinod Superstops. The Superstop is also a well-known marka and defined under Section 2 of the Trademark Act 1999, and the suit was decreed in the favor of Plaintiff, and the defendant was restrained from the infringement of the Plaintiff trademarks. Same the Pandit Kulfi Cafe and the Pandit Kulfi, and you can see the respondent have written the word Sri Balaji in very small font and highlighting the word Pandit Kulfi in the bigger font, and the customer may mislead that it must be the appellant. So the appeal was allowed, and the respondent was prevented for the use the word Pandit. So such name being very distinctly similar to the registered marka of the applicant, and the respondent prime facie is guilty of the infringement of the trademark. And same the trademark infringement case of the Amul. The Amul also won the trademark case in the Gujarat High Court in 2007, because some concluded, you can see the Amul is a well-known trademark and it is protected by the Kaira District Cooperative Milk Producer, a union popularly with the Amul Dairy and Gujarat Cooperative. So one person have filed a trademark infringement case against the two local shop owner, the Amul Chashma Sagar and the Amul Cutpiece store in the district courts, while the Kaira Union, which own the brand Amul, manage the brand. So according to the High Court decision, the district court have passed an order that it will clear case of the infringement, because the Amul is a well-known trademark, and the Amul Cutpiece centers and Amul Chashma Sagar, however, challenged the district court in injunctions in High Court, but the High Court and Supreme Court upheld the ruling of the district courts. So in the trademarks amendment into recently in 2017 occurs. So in amendment in 2017, new form will introduced, and changing the fee structures is also there, and the time of filing is very less than, and evidence in the reply is very reduced, and renewal request can be, we can file 1 year prior to the renewal date, and expedite processing of the application from the filing until registrations. So in the next one is the well-known trademark. So the a new rule allow also the determination and inclusion of the trademark on the list of well-known trademark. So the any person by filing a appropriate form with the fees 1 lakh rupees, along with the statement of the case supported by the documentary evidence, can request the register to the determine it is the well-known or not. So the to determine the whether your marka is a well-known, the registrar shall take into the account patent provisions which find mention in section 11 of Trademark Act 1999. And in perspective of Indian improvement in the administration of the trademark filing, the trademark office having right now the video conferencing as a mode of conducting hearings and comprehensive e-filing process. 90% of trademark application filed online in 2022 and 23, and there is an automated process instituted such to those of issuance of the registration certificates. And due to this one, the earlier the registration sheet was generated in 3 to 4 months. Right now, immediately generated the representation sheet. Examination earlier happened 2 to 3 year of filing. Right now, the examination happened 1 to 2 months from the filing dates, and the publication earlier it will take 3 to 4 year of examination, but right now within a 2 to 3 months of the examination, publication is happen. So the overall from the filing to grant the mark is registered within 8 to 10 months, but earlier it will take to 7 to 10 years. So in international trademarks, we adopt the Madrid protocols. The Madrid protocols having some advantage, means allow a trademark owner to obtain the trademark protection in many jurisdictions by filing a one application in one jurisdictions with the one set of fees. And we can make any changes and renew registration across the all applicable jurisdictions also. So there is a, when we file our trademark in international, there is a 3 type of the route. National route, first we file the each country where you seek the protection. Otherwise you can file the regional route, like the country member of the regional trademark systems, like the African Regional Industrial Property Office or a European Union organization, etc. And through the international route, protocols and the Madrid system administered by the WIPO, there is a 70 members country in international routes in WIPO. So this is all from trademarks. Now we can go for the copyrights. So the copyright is a very exclusive legal right to reproduce or a publish or a sell or a distribute the matters and form of something, so that no one can else be use or a copy of or a alter the work without the permission of the certain circumstances. So the copyright is also a negative rights, and we cannot protect the idea as a copyright. So the copyright is also having, we can file the several applications like the musical work, we can file the copyright application, sound recording, artistic works, cinematographic, computer software, literary works, all these are the subject matter of copyright filing. So the in case of the computer program, to do any of the acts specified in the acts, to sell or a give a commercial rental or a offer to sell or a commercial rental any copy of the computer programs. So, in case of the cinematography, to make a copy of the film, a photograph of any image, or a storing of its any mediums, or to communicate the film to the publics, or in case of sound recording, to communicate the sound recording to the public, to sell or give a commercial rental or a offer to sell or a form such rentals, or to make a any other sound recording avoiding in its including the storing of its any medium by electronic means. So there is a specific provision in our copyright. The copyright shall not be substance under this act if any design which is registered under the Design Act. If your matter is a subject matter of design filing, in that case you cannot file the copyright application of the same matter. So, or in other sense, the copyright or if you have filed the copyright applications for any designs, so which is capable of being registered under the Design Acts, but which has not been so registered, shall cease as soon as the any article to which the design has been applied has been reproduced more than 50 times by the industrial process by the owner of the copyrights with his license or with his licensing or by the any other persons. So the term of the copyright in published literary, dramatic, or a musical or a artistic works, except and otherwise hereafter in the providing, because the copyright shall subside in the any literary, dramatic, musical, artistic work for the lifetime the author until the 60 year from the beginning of the calendar years. Uh, this is the example of copyright applications. Literature is covered the novel, short story, essay, poem, manuscripts, article, computer software. In musical category, the musical notes, melodies, lyric of songs, jingles, operas, musical play, sound recording, a podcast or a DVD or a CD or a recording species or a hello tunes, a movies, television shows, online videos, stage play, video games or a slideshows or a graphics, fine arts, photographs, map, diagrams, or a architectural plans or the drawing associated with also a subject matter of copyright applications. In artistic works like a painting or a drawing, including a diagram, maps, or a you can photographs, whether or not such work possess artistic quality, or any other work of artistic craftsman. Or in the sound recording, a, a recording of the sound from which such sound may be produced, regardlessly to the mediums. Any recorded audio will be considered as a sound recording, for example a songs, recorded speeches, or a audio books. Or a literary works means the express in print or a writing or in some form of notations or a symbol or sense, somewhat similar to the use of word literatures and refer to the written or a printed matter. Or it is a distinction between the literary or a dramatic work means the literary work include but not limited to the textbooks, poem, magazine, or a catalogs or a letter or a novel or a lyric of songs, etc. But the dramatic work include the plays, screenplays, scripts, choreographic notations, choreographic shows, scenario of the films, etc. And there is a cinematographic films means any work of the visual recordings, and the musical works means the work consisting of the music including any graphical notation of such works. So in pictures you can see the script is also filing the subject matter of copyright protection. Song you can file the copyright application, singers, costumes, lyric, musics, all are the subject matter of copyright protections. The copyright does not protect the idea or a concept, and to get the protection of copyright a work must be original, and the copyright protect the expression, not the idea. And the copyright does not ordinarily protect the title by themselves or a name, short words, combinations, slogans, short phrase, methods, plots, or a factual informations. And the government work created by the government and the work without original authorships, fact and research study is not the subject matter of copyright protection. So the first thing come in our mind, that is the copyright is automatic or not. Yes, since 1978 the any new work created have a copyright protection as soon as they are in the tangible forms. So there is a no need to include the copyright notice like this one. So the work created after 1978 has a copyright protections lifelong or until 60 year after the death of authors. And the work created between 1923 and 1978 has the copyright protection for 95 years. And the work created before 1923 is in the public domain. So when we file the copyright application, the registrar of the copyright shall keep the copyright office a register in the prescribed form to be called a register of the copyright, in which we enter the name or a title of the works, and the name and address of the authors, publisher, owner, etc. And there is a several form which are used for the filing the copyright applications. In either you can file the copyright in a physical or a electronic means the part 1 related to the literary work, part 2 the musical work, part 3 the artistic work, part 5 the sound recording, part 6 the computer program, etc. So in the application for the registration of copyrights, the several applications for the registration of copyright shall made in form 14, and every application for the registration of changes in the particular of the copyright entering the register of copyright shall be made in form 15. And every such application shall made in one work only, and shall be accompanied by the fees specified in a rule. So in general, the when we file the the copyright application for the software, literary or artistic activity, the fees for filing the copyright application is 500 rupees only. And every application should be signed only by the applicants, and every application for the registration of unpublished works shall be accompanied by the two copy of the works. And in case of the computer program, we have to provide the CD to copyright office. And in case of the computer program, there is we have to provide the source code and object code. If the source code have the more than 20 pages, in that case we have to provide at least first 10 page and last 10 page of the course source code. And if the entire source code have less than 20 pages, in that case we have to provide the whole total pages of the source code. Otherwise there is no need to provide the source code of greater than 20 pages. We have to provide only first 10 page and last 10 page of the source code with no blockout or a rested portions. So every applications for the registration in respect of the artistic works which used is capable or which being used, and such applications shall include a statement that affects. And every application for registration in respect of the artistic work which is capable of being registered as a design act, such application shall be accompanied by the statement in form of affidavit that it has not been registered under the design act, and it has not been applied to the articles through the industrial process and reproduced more than 50 times. Because as soon as your article which is the copyright and it is through industrial process is replicated or reproduced more than 50 times, it is automatically abandoned, and because in that case it is a subject matter of the design act. So in the registration of the copyright, we file the application in form 14. Then examination will be happen by the registration copyright office, and if there is objections, we have to give the reply to the to overcome the all objections, and after that the registration certificate will be issued. So through the registration of the copyright, we obtain the two type of the right: economic right and the moral right. Economic right means by publishing, performing, selling, distributing, hiring, licensing in different form or assigning. And through moral right under section 57, which allow the author to take the certain action to preserve the personal link between himself and the work. And right now, one word is come under existence, the copyleft. It is the opposite to the copyrights. Means the copyright is a C in the circle, but the copyright is opposite to the C in the circle. The copyleft is an arrangement whereby a work may be used, modified, or distributed freely on condition that anything derived from it bound with the same conditions. But the copyright is the exclusive legal right to the use, copy and the distribute of a creative work. The example of the copy left and copyright is, the copyright is just like you can see the Microsoft Office window. You cannot use the Microsoft Office and the window without proper licensing, but you can use the Acrobat Reader without using the proper licensing. It is a freely available on the websites. So the freely available software, in that case there is no use of the license. This is the example of the copyleft. And the software which is a use for, which is not freely available softwares, and we need the license for that. Once it is the example of the copyrights. So there is a difference between the copyleft and the copyrights. So this is a workflow of copyright registration. We need the original copies and the software, and we need in 3 CDs. We also provide the, as I told you, the source code and the object code, and the statement of author is needed, and the justification for the registration of proposed copyright is also needed. And if in case of the joint applicant, the joint statement of author is needed. When we file our copyright application to the Copyright Office, the immediately issue the diary number, and there is a 30 days mandatory waiting period for objections. So anybody can file the objection. If there is no objection received by the Copyright Office, then scrutinized by examiner, or if there is no discrepancy in your applications, your application will be registered, and you receive the registration certificate. If there is a objection by the anyone, in that case the letter will be sent to the both party, and reply from the both party they seek from the Copyright Office, and hearing by the registrations, and both parties sit together, and after that the copyright register will be decide that your application is eligible for the registration or not. If your application is applicable for the registrations, in that case they and they found no objections, your application will be registered. It is a registered approval. If there is a discrepancy in your applications, they give the discrepancies letter to the applicant, and reply from the applicant they receive as soon as. And after that, if you are overcome the all objection which is raised by the examiners or the registrars, and after that your application will be registered. So this is the registration certificates, and this is the cert certificate. This is a letter of extractions. So the in infringement case of copyright, when any person without license granted by the owner of copyright or a registrar of the copyright in contravention of the condition of the license, or when any person make for the sale or a hire or a sale of let for the hire, or by way of trade display, or distribute either for the purpose of trades and by way of trade exhibits in the public, or import in the India, or sell apply to the import of the one copy of any work to the private or domestic use of importer. So a fair dealing with any work not being not being a computer program for the purpose like the private or a personal use, or including the research teacher to student is not amounting of the infringement of the copyright. Even the criticism or a review whether of that work or any other work is not a subject matter of infringement of the copyrights. Or the reporting of the current events or a current affairs, or including the reporting of the lecture delivered in the public is not a infringement of the copyright. So the action not amounting to the infringement of the copyright is the research or a study or a criticism or a review or a reporting of the news, or or giving of professional advice by the legal practitioner or a patent attorney is not amounting the infringement of the copyright applications. So you can earn the money from your copyright application through the license. The owner of the copyright is any existing work, or the prospective owner of the copyright in any future work may grant an interest in right by license in writing by him or his duly authorized agents. And the symbol used for copyright is C in the circles. And provided that in case of license related to the copyright in any future work, the licensee shall take effect only when the work come into the existence. So there is also a provision for recurrence of the copyrights. The author of work desired to the recurrence under section 21 or any of the rights comprising in the copyright in work shall give the notice of the register of the copyright in form 1 or give the public notice. Same the compulsory license in the work withheld from the public, because the application of the license under section 31 to republish the work or perform the work in the public or communicate the work to the public by broadcasting shall made in the form 2. The Now the importance of the copyright. The copyright, the main motive for the creating work is money, because if there is a money is disappear, nobody can file the copyright application. If the author cannot make a living writing, or a most will not write, for like the Chetan Bhagat, because he's a novelist. So if they not earn the money from that novelist, from their novel, so they most will not write. If the movie company cannot profit from the movie, they will hire fewer actors. So the main motive for the creating creative work is the money. So through the copyright, we give the license to other one. We give the license for the reproduce the songs. We give the license to reproduce the our literary activities. We give the license to the another one to the person who can copy of our literary work to the sell in the public. So if the copyright exists but cannot be enforced, the above still happen eventually. The end result is the less creative contents, and the content will not be as accessible. So there is an example. In this example, we can file the trademark, or in which case we can file trademark, or in which case we can file the copyright, or both. So in this case, you can see the trademark, and we can file the trademark and copyright both. So in the Coca-Cola bottles, you can file the trademark application of the Coca-Cola, and same times you can file the copyright of the how we wrote the Coca-Cola on put on the Coca-Cola bottles. And the shape of the bottle is a subject matter of design. It is not a subject matter of a trademark filing or a copyright filing. Even the formulation of the Coca-Cola is a filing of the trade secret or the patent applications. So in case of trademarks, the if there is a only word in our symbol, so the word is a subject matter of trademark filing only. If there is a label or a packaging, so in that case we can file the trademark application, or we can file the copyright. Or if there is a shape also in this one, so we can file the design, we can file the copyright, or we can file the trademark. So in difference between the trademark and copyright, there is a no need of the absolute novelty in both the case. The sue for infringement without registration is applicable in copyright only, but in case of infringement, we have to register the trademark first. And the passing of action will be applicable in trademark only, but is not applicable in the copyright. And the tenure for trademark is 10 year plus 10 10 10, and the copyright is the lifetime or 60 year from the death of a particular author. So in the trademarks, the trademark protect the item that help define a company brands, and even the copyright is the towards the literary or artistic works. And in trademarks, we can protect the enterprises, logo, products, name, phrase, slogan, etc. But in copyright, we can protect the books, article, even the web contents, painting, photographs, recording songs, shows, movies, etc. In case of the trademark, the exclusive right to the owner of the trademark to use it, to assign license to the another party to use the same. And in the copyright, the bundle right conferred by law that protect the original piece of work from being copied. And in case of the trademark, the issued for the shorter period, and copyright is issued for the longer periods. So, particular in case of there is a difference trademark, copyright, and design. So, absolute novelty is required in design filing, but there is no need of the trademark and copyright filing. Passing off is applicable in trademark only, and sue for infringement without registration is applicable in only copyright applications. So when we see the difference between the copyright, patent, and trademark, the copyright is protect the expression, not idea, and the patent protect the ideas that have been reduced to the practice, and the trademarks the protect the goodwill associated with the marks. And in the copyright there is a fair use policy, but in patent there is no fair use policy or a research exemptions. And even in trademark there is a fair use policies there. And in copyright, work for hire, employee and inventor owns in the patent applications, and in trademark the owned by the person that used in the commerce. And in copyright it's protect against the copying, and in patents the innocent infringement, not a difference. And in the trademark, the protect against the confusion or a dilutions. And in copyright the protection is automatic, registration is relatively very simple, but in patent application the extensive examination process before any right granted. And in same in the trademark, the automatic for distinguished mark might need meanings, and some examination will be happens only. And in copyright the originality is a very low bar, and but in patent applications the novelty and non-obviousness in the high in bar, and in trademark the distinctiveness is in high in the bar. So this is the another examples in a cup of tea. In this nice cup of tea you can file the several ip, like you can file the copyright application or for a literary works, books about the tea, automatically receive the copyright protections. Same that trades, you can file the trademark brand, give the consumer confidence, like the Tata tea or Taj Mahal tea, Darjeeling tea. So it's allowed the tea producer to stand out from the competition and the fight copycats. And you can file the design application, the looks and the feel of tea products, such as the cups and the packaging can be protected through the industrial designs. And even you can file the trademark secret, a secretly kept tea recipe. And even you can file the patent application, the tea related invention like the kettles, filtering solutions or a tea production methods can receive the patent protections. And you can file the geographical indication for the patent tea, also like the teas with the specific quality and the flavor linked to their geography, like the Darjeeling tea with the example of geographical indications. So all are from my sides, and now I'm happy to have a question from the audience if there is. Yeah. Yeah, ma'am.
Thank you, Dr. Kibulde, for your enlightening and inspiring speech on innovation and intellectual property rights. Your profound insights have provided us with a deeper understanding of the importance of this concept in academics and research. Your expertise and wisdoms have undoubtedly left a lasting impressions on all of us present here today. We are truly grateful for your valuable contributions to our faculty development program. Thank you, sir.
Thank you, ma'am. Thank you.
Um, Dear participants, now I will share the attendance link to you. Any queries or questions is there? Please post in the chat. Now, questionnaire session is there. Please post your questions in the comments. The question is, what is the timeline for patents, copyrights, and trademarks? Sir, one of our participants asked, what is the timeline for patents, copyright, and trademark? Till that, I will give you one guideline. Attendance and feedback link is posted above. The link will be available for the next 20 to 25 minutes. Participants who have attended these sessions, kindly post your attendance. For your information, certificates will be given only for the participants who have posted attendance for all 5 days.
Yes, ma'am. It is audible.
Sir,
Yes. The one key, yeah, one question I can see the. Could you tell us the patent more useful for computer science field?
yes,
Actually,
yes.
yeah. Actually, the patent is more useful for the in the field of the computer science field, because the in case of the copyright, when we file the any software in copyright protections, so. Because in the computer science field, the software is not a subject matter of patent filing. So when we file the patent application of particular software, so we need the software embedded into the hardware. So in that case in that case is only a subject matter of patent protections. So in the computer science field, when we file the patent application, we need the hardware or the software both. Alone software is not a subject matter of patent protection. It is only a copyright protections only. But when we embedded the software into the hardware, in that case only it is the subject matter of patent protection. So if we would like to file the patent application of any computer related or a computer science field, we need the software which is the embedded into the hardware. So we have to show the efficacy of that one. So in that case, we can it is surely say that the patent is a much more broader protection compared to the copyright. But we need the patent protection, the hardware and the software both. Alone software is not a subject matter of patent filing. So next question is the what is the timeline for the patent, copyright, and trademark? So the when we file the patent applications, when we file patent application and after 18 months it is published by the Indian Patent Office, and within the timeline limit of the 31 months we have to file the request for examination. So it will take 3 to 4 years for filing the trademark application or a granting. And but in the copyright, the time duration from filing to granting is only 3 to 4 months. You get the copyright certificate, copyright certificate within the 3 to 4 months. Same in the trademark, you get the certificate for the trademark 7 to 8 months. So the filing to granting in the patent application, it will take time 3 to 4 years maybe, or it maybe take time 2 to 3 years. But in the copyright it will take 3 to 4 months, or in trademark it will take around 9 to 10 months only. So how long how long will it take to file for a patent? So when we how long will it take to file for a patent applications? Okay, patent. So when we file the patent applications, first you file the patent application in particular jurisdictions. After that, it will take 18 months for the published by the Indian Patent Office, and we have to file the request for examination within the timeline limit of the 30 months from the first filing date. That after filing the request for examination in the patent office, your patent application will be examined by the Indian Patent Office, and after that they issue the first examination reports, and we have to give the reply the first examination report within the 6 months. And after that, whatever you reply give to the patent office further examine, and if the all objection will be addressed by the inventors, it is okay, and your patent application will be granted. Otherwise it is given an opportunity to the hear again, and you have to interact with the controller of the patents, and after that you have filed the response of the particular hearing notice, and then it is decided that your application will be granted or not. So it will take time 3 to 4 years from the filing to the granting of the patent applications. A logo of Puma is a 2-dimensional feline, okay, which on the other hand Jaguar is the 3-dimensional feline. Okay, so the Puma and Jaguar, so both have the different business. Puma is in the shoe business and the Jaguar in the automobile sector. So there is a two different business. So the two different business cannot interfere to each other. So both logo can be granted. But if the logo of the particular company and they are doing they are indulged in the same business, like the example of the McDonald's or a Domino's, if they have the same logo, because they are having the restaurant sectors, both are indulged in the restaurant sector, in that case only it is applicable. But in case of the Puma is a shoes brand and the Jaguar is not a shoes brand, so they can be it can be applicable. Same the example, I will give the example of Amul is the one Amul used for the dairy sector. Same the Amul is used for the clothing sector. Amul Banyan, Amul or underwears also. So or even Lux Koji is the garment sectors, and same the Lux in the soap sector. So they have the different business. So we have to, when we file the application of the such type of the trademark application, we have to show that our business is the entirely different from the other enterprises. In that case, it is a granted one. Yes, the trademark is used for the business only, because the marka which is used for the trading purpose is only a subject matter of trademark filing. And for the research people, for example, if I have research in I have developed some products, and it is already patented, but the same product I just launched into the market. So before launching into the market of the products, I need the some marka, because the marka, through the marka you have show the you have show the image of that product in a market. So before launching the your product, which are already established in the labs, come into the market, you need the some marka, because without marka you cannot enter into the market before. So some marka should be necessary for entry into the market, because through marka your image of that product will be created out. For example, for the Apple in the telecom sectors or in the telecommunication sectors, Apple is the trademark, and it is a discovered a several products in our labs. For the iPad, it's manufacturing the phone, etc. When they launch the any phone into the market, because phone is the one product, and it is a launch the phone into the market, they need some trademark for that one. Same the I can the example of French fry. The French fry is also an example of the trademark which is owned by the brand of McD. McD having the several trademark, like the for burger, for a French fry. When he launched a product French fry, and it is a launch the French fry into the market, they give the trademark applications, file the trademark application name of French fry. So this is the important sector which are the used for the when we do research, and the research and product is the generation of the product, and same product we monetize into the market. So before marketing launch in the market, we need the some marka to monetize that products. For registration copyright means it should be not be published. No, there is no need for the, because the copyright is the automatic process. As soon as as soon as in the tangible form, it is automatically registered. There is no need of the registration. But when you monetize the copyright, copyrights or a literary activities or an artistic activity, in that case only you need the registration. Otherwise, a copyright is the automatic process. Yeah, Puma and Jaguar have the same symbol, but they doing the different business, because business is different. They have to show that they show the GST invoice. They have the place of business is to when they file the trademark application, Jaguar and Puma, because in that case they have to show that our business is entirely different to each other, and our business is entirely different from the one enterprises to the another enterprises. But there is a fair advice that it should be not happen, because in that case it is not easily forcible things, because when they are doing the same logo, in that case they create a confusing. But we have to show, when we go into the trademark registry, we have to show the whole thing that our business is in different way, and another enterprise is having the different ways. So we have to show the particular invoices, particular place of business, particular revenue generations. Also we have to show that our revenue generated through the telecom sector, or our generation to the shoe sectors, or a leather sectors, or our revenue generation through the automobile sectors. So there is a different sectors from through we obtain the revenue generations. Could you please explain about the renewal of patent, after how long it is valid? Say for yes. For when you file your patent application and it is granted, after that you have filed the renewal in every years. If you fail to renew your patent application, it is automatically abandoned by the patent office. For the filing the renew, you have to pay the renewal fees for the each and every year. So first 2 years there is no need to file the renewal fees. It is a waive off by the patent office. After onward 3 years to 6 years, the fees is very less. After that, 6 to 10 years, the fees is higher. 10 to 15 years, it is a much higher, and 15 to 20 is much higher. For the total renewal fees for the second year to the 20th year is around for 70,000 rupees. If any inventor would like to renew their patent application from first year to the 20 year, they have to pay the 80,000 rupees for the entire term periods. What is the login of the stating 60 year of the validity of the copyright in India? Actually, before there is even a good example of the Gitanjali created by the Rabindranath Tagore. Before this one, the term for the validity of copyright is only 50 years. After the amendment to the protect the Gitanjali of the Rabindranath Tagore, they increased the term period from the 50 year to the 60 year in India. In US, the copyright protection is the 70 year in somehow states, but in India it is a 60 year in case of the death of author. Otherwise, it is the lifelong protections. There is not a 60-year protection. But in case of the death of author, the legal heir can enjoy the protection or enjoy the monetization till the 60 year from the death of author particular. Does trademark, patent, copyright of a particular concern come into the hand in hand, and are they are independent? No. The patent, trademarks, and copyright are not dependent to each other. But somehow we can say it is a dependent, because when you file your trademark patent applications and you granted your patents, and then you have some product in your hand, and that product you come into the you would like to enter that product into the market. In that case, you need the either trademark filing or a copyright filing. So in that case only it is a dependent to each other. Otherwise, it is a independent to each other. The patent is a somehow different things, and the trademark and copyright is somehow different one. Uh, does the trademark, patent, and copyright of a particular concern come in hand, and are they are dependent? No, there is no dependent to each other. Just I'll tell you, they are not dependent to each other. They are separately things. The trademarks, patent, and copyright are the all entire separate phenomena, and the trademark and they are governed by the several acts and different acts and rule, and they the protections and the maximum protection is also a difference, and even the filing instruction is also difference, because in case of trademark applications, the copyright is automatically protected. There is no need of the copyright registrations. But in case of the trademark, you have to file the registration in case of the infringement. But in case of unregistered copyright, anyone, if there is a infringement, in that case anyone can file the infringement case against the party. So there is no need for the registration for the copyright. The copyright registration is only needed for the monetize of that ones. But in the trademark, the registration of the trademark application is need for the protect from the infringers. And same the patent is also somehow different, because in patent you can protect the ideas which is reduced to the practice. But in copyright, there is you have not protected the ideas or concepts. But in trademark, there is need a marker. Marker is your creation of your minds. It can be it is a marker which is used for your business purpose. How you introduce your product into the market, and how what is the reputation of your product is in market is depend upon your marker.
Thank you, sir. Now, as we are drawn towards the conclusion of this enlightening sessions, it is my pleasure to invite Mr. A.P. Babu, Assistant Professor, Department of IT, to deliver the vote of thanks.
Thank you, ma'am. Good afternoon to all. I am A.P. Babu, an Assistant Professor of Information Technology Department at Dr.M.G.R Engineering Research Institute. It is a wonderful honor and privilege to me to offer the vote of gratitude of this particular occasion. Let me begin by expressing my gratitude to God for making this event a huge success. I would like to thank Dr. Kapil Arya, Principal Scientist of CSIR IPU in New Delhi. I appreciate you, sir, for such a insightful and knowledgeable talk about copyrights, trademark. With a great pleasure, I extend my gratitude to our esteemed and vibrant President Dr. Engineer ACS Arun Kumar sir, who has been an invaluable source of continual support and constant source of inspiration for us to keep moving forward. I also thank our Vice Chancellor Dr. S. Geeta Lakshmi ma'am, Registrar Dr. C. Banivel sir, Additional Registrar Dr. V. Cyril Raj sir, Advisor Dr. Mehta sir, and Dean Engineering and Technology Dr. Etiraj sir for their guidance and encouragement in all our efforts. My sincere gratitude to my head, Dr. N. Kanya ma'am, and my wonderful colleagues for their tireless effort in making this event a historic one. Thank you very much to everyone who took part in this discussion. Thank you for your time once more, everyone. Thank you.
Thank you, sir. I extend our sincere thanks to you, Mr. A.P. Babu. Your contributions has added immense values to this gathering, and our words have left a lasting impact on all of us. Thank you.
Electronic and Communication Engineering, Electrical and Electronic Engineering, Computer Science and Engineering, Electronic and Communication Engineering, Biotechnology. Rajarajeshwari Medical College and Hospital is a dynamic, reputed, highly acclaimed institution situated in the serene 25-acre campus in southwest Bangalore. The college has state-of-the-art central research laboratory with qualified and trained personnel. The fully modular operation theatres in the hospital are equipped with the most advanced systems and devices. Highly experienced, top-notch surgeons undertake complex surgeries in a spectrum of specialties, thus helping the patients to get the best clinical care. ACS Medical College and Hospital, Chennai. This spacious, well-ventilated and audio-visual equipped lecture halls and classrooms are designed to provide space for CMEs and training sessions for the doctors, students, staffs and nurses and technicians. Faculty of Medicine, Sri Lalitambigai Medical College and Hospital. The hospital has a wide range of round-the-clock laboratory infrastructure with skilled staff providing prompt service to the patients. The ICUs constitute the pride of the hospital healthcare delivery. The well-stocked pharmacy in the hospital works around the clock. Faculty of Dental Surgery, Thai Mogambigai Dental College and Hospital. Faculty of Architecture. Faculty of Arts and Commerce. Faculty of Humanities and Sciences. Faculty of Law.
Faculty of Physiotherapy.
Skilled staffed physiotherapy department helps in the rehabilitation process.
Faculty of Pharmacy.
The workout pharmacy in the hospital works around the clock.
Faculty of Nursing. Faculty of Allied Health Sciences. Computer Applications. Faculty of Hotel Management, de novo courses. Faculty of Education. General Facilities.
Library is a treasure trove of knowledge. Fully equipped ambulance services, multi-cuisine nutritional cafeteria for students and the staff, gym facilities, separate sessions for men and women, comes with all exercise equipment. A spectacular cricket ground and separate swimming pools for boys and girls.
Few of our events in lineup. Degrees are awarded to the graduates on the convocation day. Dr.M.G.R. University, providing education with moral and social values to bring out the youth with character and humility beyond compare. Following the footsteps of a phenomenon, Bharat Ratna Dr. M.G. Ramachandran, former Chief Minister of Tamil Nadu, for meaningful progress and better tomorrow.